Legal expert Ulrich Roux joins us now in studio to discuss the matter. Was the magistrate's decision clear? Ulrich?
Well, yes, I think that he considered the application. Remember that the accused in that matter had already been released on bail. So this was an application for the bail conditions that had been imposed when they were released on bail to be relaxed just for this instance, in order for Varun Gupta to go to India for religious purposes and then to return on the 27th of May. And I think Aaron pointed it out that the legal team argued you cannot punish a person prior to him being found guilty of anything. And the magistrate would have obviously weighed up this application and the accused's right in that sense versus the risk of him absconding and not coming back to South Africa to stand his trial. And
that, in fact, is the question that's in the minds of many people who are following this case. It's what if, he does not return, and especially given the fact that his wife and kids are already outside of the country.
Yes, well, the magistrate must have been satisfied that he has proven a case that he is going to come back to South Africa, that he's purely going for these religious purposes, and that his version that he's returning by the 27th of May is believable. If there was any risk in the magistrate's mind or any doubt that he would return, then he wouldn't have granted the order. So one can only assume that the application was a good one and that it convinced the court accordingly.
Of course, an important issue or fact to underline is the fact that the NPA had never considered him to be a flight risk in the first instance. Would that have played a role in how the magistrate arrived at the decision?
Yes, definitely. And remember, when a person is released on bail, in this instance it was a Schedule 5 bail application, so the accused had to prove that it was in the interest of justice for them to be released on jail. And bail is not punitive. It is purely there to ensure that a person stands his trial until finality, whether he's found guilty or whether he's acquitted at the end of the trial. And obviously they proved that he's not a flight risk at the time, otherwise he would have not have qualified for bail. So this was purely an application to say that he urgently needs to go to India for these religious purposes. The bail condition was that he had to inform the authorities 6 weeks prior to such a departure, and they are requesting the court to grant them this permission in a shorter period. And again, the fact that he was released on bail at the outset shows that he's not a flight risk, and the magistrate must have been convinced that he's going to return for his trial.
And what of the role played by the fact that the state did not counter the application or present new evidence?
Yes, that is telling. Obviously, if they had no evidence to counter the application, then it's telling that they cannot prove that he's going to be a person who absconds from his trial and is not going to return to South Africa. Otherwise, they would have presented that evidence to court. So again, he had made out a case that he's going to return to stand his trial, and as the magistrate said, the ball is now in his court, and he has faith in him that he's going to return, and he has until the 27th of May to do so.
But what about then the interest of justice at the end of it all? Yes, he may well have been within his rights to make the application, and the court may have considered everything in front of it and said, well, you haven't presented, the state didn't present any counter application, they didn't present any new evidence, so the guy can go. But at the end of the day, this is a case that goes to the detail of one of those important chapters in the history of this country. We have never seen anything like the Gupta capture in the 20-odd years that we've been a democracy. So it becomes very important for each and every witness that the state can lay its hands on to be available, not only to give us a sense of what the depth of this problem, but to ensure that justice is indeed done. Would that have been a consideration even, or did the magistrate purely look at the facts in front of him?
I think you answered the question by saying the interest of justice. And justice also dictates that a person who has not been found guilty of anything thus far cannot be penalized. And that is what the magistrate would have weighed up today. You know, is there enough reason to believe that if this person goes to India, he's never going to return? And if there's any reason to believe that, then he wouldn't have granted him this indulgence. And obviously, once again, he found that there's no reason to believe that, and that this person is going to come back. It would have not been in the interest of justice if he penalized him by not being able to go, even if there was no grounds for him doing so. So that's the difficult balance that a presiding officer, a magistrate or a judge needs to balance at the end of the day. You know, the interests of the accused person versus the interests of the state, and versus what's in the best interest of society and justice, because justice at the end of the day must prevail at all times. And if you deny a person the right to exercise his religious beliefs, just because the entire country believes he's a criminal, but it hasn't been proven thus far, then that is not justice. And that was the main consideration that the magistrate would have taken into account today.
Very briefly, hypothetically, and I'm probably being facetious even, would the magistrate have arrived at that decision even if he personally felt, you know what, I think this guy is actually a flight risk, given that his children, I mean, his family is not even here. But because I'm hamstrung by what the state has or hasn't done, so I have to allow this guy to go.
Remember that a judge or a magistrate is a creature of statute, so he's bound by what our act says. And he must divorce his own personal beliefs from what is presented in front of him and what the act allows him and allows him not to do. So, you know, even if he thinks that he is guilty, he must go on what's presented in front of him and what the act says, and that's what he did today.